Court is resumed. Please be seated.
Good afternoon, Your Honor. Checking to make sure everyone's ready. I think they are. Just before I turn to the second topic, which is relative wealth disparities and unequal distribution of the benefits of the resources, I thought I'd offer a different way, perhaps, of looking at spectrum. We disagree with Canada's contention that revenue from spectrum does not arise directly or in a closely related way to the use, sale, or licensing of land. In our submission, spectrum is a natural resource. It is comprised, as we know, of radio waves or particles traveling at various frequencies. Other particles comprise the water that runs over the land, the minerals under and on the land, and the vegetation on the land. Spectrum waves go over the land. Users of spectrum are on the land, and the facilities required to utilize spectrum are built on the land. So we say that revenue from spectrum arises, to use those words, directly or in a closely related way to the use, sale, or licensing of land. And further, hearkening back to the language of paragraph 2B of the amended Stage 1 judgment, it is our submission that this was a future opportunity within the meaning of that paragraph. Now, with that, I turn to the second major area that I'll be addressing, and that is relative wealth disparities and an unequal distribution of the benefits of the resources. And we address this topic at paragraphs 136 through 168 of our primary written submissions. The starting point is paragraph 322 of the Court of Appeals decision, which is found at page 63 of our compendium. And here again, we are looking at the reasons of Justices Lowers and Pardue. And I will now read paragraph 322 at a reasonable pace. Based on the trial judge's reasoning, the common intention of the parties was to share in such a way that would provide for both communities. This would suggest that the share promised is to be determined not only based on the extent of Crown revenues, but also with reference to the relative wealth and needs of the different communities. Obviously, the Anishinaabe would not have expected their communities to suffer a range of deprivations, including substandard housing and boil water advisories, while non-Indigenous communities thrived. Nor was it likely, based on the Anishinaabe principles discussed by the trial judge, that the Anishinaabe would have wished to enjoy great personal wealth while their fellow Canadians suffered deprivation. Now, of course, during Stage 3, the court heard evidence about the range of deprivations that have resulted from the Crown's failure to live up to its obligations under the treaty. And I want to focus on one particular aspect of this evidence in my submissions, and it shows where the Crown directed the benefits and burdens of the resource development in the territory. As a result of the access that the Crown received to the lands, trees, minerals, and waters of the territory, the new settler population was able to benefit immensely. Resource extraction companies like Kimberly-Clark and Ontario Paper were able to build company towns to attract workers with great amenities. And this while mere kilometers away, the Anishinaabe, deprived of their share of the resource wealth being extracted, were living in harrowing conditions. And this was the result, at least in part, of the Crown's conduct in failing to honor its treaty promise and augment the annuities. And for a graphical representation of this, I turn, as Mr. Schachter did, to Exhibit 11, the trial demonstratives of Mr. Hutchings, slide 305. This is in our compendium at page 65. And this illustrates how the Crown disproportionately directed the benefits of the resource extraction in the territory. It demonstrates that resource extraction was used to benefit the non-Indigenous population and not the Anishinaabe. It shows that as resource extraction picked up in the territory, the standard of living of the non-Indigenous population tracked that increase. On the other hand, the well-being of the Anishinaabe barely improved. But the evidence from the chiefs and elders put a human face on the deprivation suffered by the Anishinaabe as a result of the Crown's failures to live up to its solemn commitments under the treaty. And in my respectful submission, that evidence is striking.
Mr. Gover, I'm going to interrupt for a second. I seem to have a technical problem. So we're going to take a break.
All right, thank you.
Taylor, I need your help. Taylor. Yeah, I'll stay here.
Okay.
Support is stood down.
I'd like you to go back to kilometers away. The Anishinaabe lived in harrowing condition.
Sure.
Thank you.
And I preface that by saying that as a result of the access that the Crown gained to the lands, trees, minerals, and waters of the territory, the new settler population was able to benefit immensely. Resource extraction companies like Kimberly-Clark and Ontario Paper were able to build company towns to attract workers and company towns with great amenities. While mere kilometers away, the Anishinaabe, deprived of their share of the resource wealth being extracted, were living in harrowing conditions. At that point, I referred to the chart, which we have as Exhibit 11, the trial demonstratives of David Hutchings. I will slow down. Slide 305, which has already been referred to.
And this is at your page 65?
Yes.
Thank you.
Exactly. And it was my submission that this illustrates how the Crown disproportionately directed the benefits of the resource extraction in the territory. It demonstrates that resource extraction was used to benefit the non-Indigenous population and not the Anishinaabe. And it shows that as the resource extraction picked up in the territory, the standard of living of the non-Indigenous population tracked that increase. But on the other hand, the well-being of the Anishinaabe barely improved. It was then my submission that the evidence of the chiefs and elders put a human face on the deprivation suffered by the Anishinaabe as a result of the Crown's failure to live up to its solemn commitments under the treaty. I submitted that that evidence is striking, and that takes me to where I left off.
Thank you. Can I ask you, when you say the Crown directed resources in a certain way, or the Crown directed benefits, what do you say are the indicia of directing?
Well, I say that Crown policy choices clearly resulted in the ability of resource extraction companies like Kimberly-Clark and Ontario Paper to create communities, that was done with the encouragement of at least one level of government, at least one emanation of the Crown represented in this courtroom, and that overall the scheme, and I don't mean that in a negative way, a pejorative way, I simply mean the policy choices taken together.
And for example,
Contributed. Well, setting stumpage fees at a certain level, for example.
of setting the prices.
Yes. Yes. And that allowed industry to thrive while deprivation was being suffered by the original inhabitants of the land who'd given up their greatest gift.
Thank you.
And in connection with the deprivations, I would remind the court of the evidence of Chief Machano initially, and we have that excerpted at pages 67 through 76 of the compendium. And I will, in large measure, summarize that as follows. And this in the transcript is pages 2257 through 22. Pardon me. Oh, it has two different parts to it, but let me start with a summary of what Chief Machano testified to. He contrasted the standard of living at Big Dugong Nishnabeg with that in Terrace Bay, established by Kimberly-Clark, Heron Bay South, established by Ontario Paper, and the town of Marathon. It was his evidence that Heron Bay South, just 2 kilometers to the north of Big Dugong Nishnabeg, was, as he put it, a fully functioning community. It had electricity, running water, and a sewage system, although raw sewage was dumped into the Pic River. Terrace Bay had all of those things and featured a golf course and an arena.
Sorry, and which one are you starting with? Marathon? Did you start with?
I started with Heron Bay South, just 2 kilometers north of Big Dugong Nishnabeg.
Right, thank you.
And the second one I refer to as Terrace Bay, which had the amenities that Heron Bay South had, plus a golf course and an arena. Marathon, another fully functioning modern community, had an arena, a curling rink, and an outdoor swimming pool. But at Big Dugong Nishnabeg, Chief Machano testified, and we have this at page 69, starting at line 11. We had nothing. There was no electricity or running water. He testified that electricity only arrived in the late 1950s or the 1960s. He testified that the inhabitants of Big Dagong got their water from the creek. There were no wells until the late 1960s or early 1970s. And of course, his evidence, I remind you about what the communities would do, what his community would do with augmented annuities. What it would have done was so focused on infrastructure, on something that would have lasting benefit for the communities. But he, at page 71, after referring to what he called the nice outdoor pool with nice blue-green water that he saw in Marathon, he testified, and this is around line 15, Your Honor, I could see the kids swimming there. And I used to wish I could go there and swim in that pool because I had to swim in the muddy old Pick River. The court will recall the evidence of Elder Goodchild, which of course has struck many people in the courtroom. And I won't, of course, endeavor to summarize all of it, but he described a range of hardships that included substandard food. You'll recall that unforgettable evidence about scavenging at the side of Highway 17 for food, about sleeping on a floor covered by coats, about the lack of running water, about the poor sanitation conditions that prevailed. But if I could take you to one last aspect of the evidence on this subject of deprivations, it's at page 79 of the compendium. And here, Elder Goodchild was asked the question, how did the houses in Terrace Bay compare to the tar paper shack you lived in Rossport? He responded, starting at line 8, ha, my God Almighty, I would love to have one of those. It was amazing. I still envy those people that had those houses. My shack, you could hear the wind blow through at night sometimes, the north sides. Pardon me, the north winds. Over there, it was warm. I walk in there, I thought it was a palace. In some of those houses I seen outside. Nice little yards, nice little fence. And the windows, there's no cardboard windows on those, or plastic windows. I said, wow, what a world. A complete different world compared to where I came from to there. My point is that had the Crown diligently implemented the treaty promise, that stark disparity would not have occurred.
Can you remind me the distance between Big Tagong and Terrace Bay, or the distance? You know that?
Can I get back to you on that,
Yes.
Your Honor? We will get back with a precise figure on that. Thank you.
It was a question I should have asked earlier. I knew it was coming.
That stark disparity in my submission is a reflection of the loss suffered by the Anishinaabe, a loss that arises from the Crown's breach of its duty. And it is a loss for this court to address in its award for past compensation. The third and last area that I will be addressing has to do with Canada's population sharing model, which we respectfully submit is inappropriate. And I can be brief in relation to this topic because Canada's own expert has recognized the inappropriateness of the population sharing model that was offered by Dr. Mintz and Mr. O'Riordan. This takes me to pages 82 through 85 of our compendium. And thanks to my friend from Canada, I already have an answer about the number of kilometers between, this really is a testament, I think, to the cooperation of counsel on this case, Your Honor. But the distance is 1 hour and 6 minutes driving, call it 93 kilometers, and that's via Highway 17. And I'm told that in the transcript, it's at page 2264, so we did have some reference to it. But independent verification is always good. So back to the evidence of Mr. O'Riordan.
So that's right. You say Canada's own expert recognized the
that the 10% number that he gave as the basis for the population sharing model is inappropriate. And of course, the point is that that's an estimate of current population, one that didn't take into account the relative proportion of the Anishinaabe and non-Indigenous populations from 1850 going forward, which would have had to be measured incrementally all the way along.
In fact, I was going to ask you to remind me what population sharing model meant. Is it the proportion, relative proportions of one community to the other?
Yes, that's it.
Thank you.
And with that in mind, and thank you, Your Honor, at page 82 of the compendium, you have, starting at line 3, Mr. O'Riordan say this: the 10% today is probably a much lower proportion of the population than it was historically across the 19th century. He also acknowledged on page 82 that, and this starts at line 14, the population across the time horizon would be relevant. And that he and Dr. Mintz did not engage in that analysis. The answer there at line 18, no, we didn't. In fact, he said at pages 82 and 83, so near the bottom of page 82 and carrying over to the top of page 83, it would also be important and relevant to look at population as proportions changed over the relevant time horizon. The conclusion there being at line 2 on page 83. Mr. O'Riordan said that the estimates of around 9.6 or 10% were, and I quote, illustrative numbers only, end quote, and that he and Dr. Mintz had not sought to obtain more precise numbers. The reference to illustrative numbers only, you'll see at page 85 at line 11, his acknowledgement at line 12, and that he hadn't sought to obtain precise numbers, that at line 17 through 19.
Let me just mark those, please. Thank you.
Thank you. Now, nonetheless, at paragraph 20 of its primary written submissions, Canada refers to the 10% population sharing model proffered by Mintz and O'Riordan, with the only proviso being that it did not take into account the relative wealth and needs of the Indigenous and non-Indigenous communities. Canada repeats its reliance on Mintz and O'Riordan's illustrative number of 10%, again at paragraph 254 of its primary submissions, arguing for doubling what it calls the, and I quote, the RST First Nations share to 20% to reflect historic deprivation. You'll see that at paragraph 262. So my point, having referred to the evidence, is that Mr. O'Riordan himself did not stand by the 10% population sharing model in the first place. And it is not, with respect, a valid starting point. And we address this point more extensively in paragraphs 13 through 23 of our written reply submissions. It is an aspect, Your Honor, of what we call Canada's false artifice of reasonableness in our written reply submissions. And subject to any questions on what I've covered so far, Your Honor, Mr. Bass will address Ontario's risk adjusting approach, the relevance of equitable compensation principles, especially in relation to remedies, and the appropriate means of calculating the present value of what should have been paid to the Anishinaabe under the augmentation clause had the treaty been honored. Mr. Bass will also set out our position concerning the submissions made by the Name-Goosasagagan community and Canada on the subject of holdback, and also on the suggestion by Ontario that there ought to be a delay in the issuance of the court's judgment in relation to this matter.
Okay,
Thank you very much, Your Honor.
thank you.
Good afternoon, Your Honor.
Thank you.
I am Spencer Bass, and as Mr. Gover mentioned, I will be providing the rest of the closing submissions on behalf of the group of 7. And I will cover 4 topics in my submissions. I expect to take the balance of the day and likely a bit of the morning tomorrow as well. And I'll be addressing why Ontario's proposed risk adjusting approach is inappropriate in this case and inconsistent with the common intention of the parties, why principles of equitable compensation are relevant, even in the absence of a finding of fiduciary duty. And within that topic, I'm going to be making comments on the recent Court of Appeal case in the Chippewas of Nawash. I will then discuss how to properly account for the present value of the lost opportunity. And that's my submissions on the appropriate bring forward rate, as it's been referred to. And I will also address the submissions regarding a proposal for a holdback in favor of the Name-Gusa-Sagagan community.
I presume when you do present value, you're doing, if compensation is looked at as being claimed for lost opportunity and breach of the promise to pay or to increase the annuity, you're looking at present value of that as well, of the compensation.
Precisely. And so moving to the first topic, the risk adjusting approach. And Ontario's proposed approach is to calculate annuities based on the risk adjusted value of NCRRs looking forward from 1850. And we submit that this approach is fundamentally inconsistent with the common intention of the parties behind the augmentation clause.
Thank you.
And as a starting point, I would note that Professor Smart and Professor Bodway themselves were, I would say, somewhat ambivalent about the risk adjusting approach. They described it as their preferred model of a number of different models that they presented to the court. Nevertheless, it now appears that Ontario has fully embraced it in their submissions as the approach that they're urging upon the court, which is why I propose to address it today. And we argue that the risk adjusting approach should be completely disregarded for two main reasons. First, it has no historical support whatsoever. And secondly, it is completely at odds with the common intention of the parties. And that's especially the Anishinaabe perspective and the desire to take care of future generations.
Thank you.
So on the first point, Ontario has not pointed to any evidence of any party, whether the Anishinaabe beneficiaries or the Crown officials, of any of these actors advocating for, proposing, or even discussing an approach similar to the risk adjusting approach in order to calculate annuities. And I would note that in stage 3, Ontario commissioned a very lengthy report from Dr. Von Gernot on the opinions and actions of Crown officials in implementing the annuity provisions of the treaty. And completely absent from the 400-page report is any reference to risk adjusting. And tellingly, in Ontario's lengthy and detailed examination of Dr. Von Gernot, Ontario's counsel asked no questions about risk adjusting or the risk adjusting approach. And so it was actually counsel for the group of 7 who ultimately asked Dr. Von Gernot about the approach. And what was his answer? I would submit that he appeared to have never even heard of the concept of risk adjusting before. And I want to take you briefly to his evidence on this point, which we've included at page 90 of the oral compendium. And so the question began at line 16. The question was, and of all the Crown officials that suggested or raised this option over the years, and the option that's being referred to there is the option of including revenues into a capital account and generating interest from the capital account. So of all the Crown officials that raised that option, none of them argued that the amount that should go into the capital fund to produce the interest should be some risk-adjusted portion of the proceeds. And by that, I mean some portion of the proceeds that is adjusted down based on the risks that the Anishinaabe would have considered back in 1850. And Dr. Von Gernot answered, I honestly don't know what you're talking about. I then returned to the subject.
You're sure he got the question?
Pardon?
You're sure he got the question?
Well, I returned to the concept soon afterwards and asked the question again in slightly different terms, beginning at line 6 on page 91 of the compendium. So none of these Crown officials suggested that if we're going to build this capital sum, the amount that goes into the capital sum is not the proceeds of the land, but some lesser portion of the proceeds that we need to adjust downwards based on the risks that we believe the Anishinaabe would have viewed in 1850 of the returns from the lands. And then Dr. Von Gernert answered, I have found no evidence whatsoever in the voluminous documentation that I examined that anyone was talking like that. So he gave a pretty definitive answer. He saw no evidence anywhere in the historical documentation, any Crown official ever discussing the concept of risk adjusting. And that's actually consistent with the evidence of Professor Smart himself, who did not propose or suggest any historical background, any historical support for the risk adjusting approach. I'm not going to take you there directly, but I note that we have included Professor Smart's testimony on that question at page 95 of our compendium. And this lack of historical evidence is unsurprising, given the inconsistency of the model with the parties' common intention. And we submit that the risk adjusting model is inconsistent with the common intention of the parties to develop a wait and see model to annuities and the value of the land. And Mr. Schachter provided some comments on the risk adjusting approach in this basis. And I wish to only point out a few more aspects. And that's the fact that in its closing submissions, Ontario has only sought to justify this risk adjusting approach from the Crown's perspective. And I want to take you to what Ontario says in its original written submissions to justify the risk adjusting approach. And we've actually included sections of their closing submissions at page 87 of our compendium. And specifically, I want to take you to paragraph 426 of Ontario's submissions.
Shall I go to your closing submissions, page 87?
It would be page 87 of the oral compendium.
Of the compendium.
Or page 117 of Ontario's original closing submissions, wherever Your Honor prefers to go.
Thank you.
And so this is included in the section of Ontario's closing submissions entitled Risk Adjustment Reflects the Parties' Common Intention in 1850. They've made the submission that risk adjusting is consistent with the common intentions. And what's their justification for that proposition? Well, the bulk of it is contained at paragraph 426, where they write, the common intention of the parties must be informed by the principal reasons why Robinson proposed the augmentation clause. Importantly, the fundamental uncertainty in the value of the RST territory. Risk adjustment reflects that underlying reality. As discussed above, uncertain future payments should be discounted at a higher interest rate to reflect the uncertainty or risk. From the perspective of an official in 1850, a volatile future stream of revenues is worth less than a fixed stream of revenues. Risk adjustment determines how much of a discount a reasonable person would expect to pay in the present for a risky stream of revenue in the future. And I would submit that what jumps out immediately, at least to me from that passage, is that there's actually no mention of the Anishinaabe at all. They're absent from that passage. And this is consistent with the evidence of the proponents of the model itself, Professor Smart and Professor Bodway. And for that, I take you originally to page 94 of our oral compendium. And this is in the testimony of Professor Smart when he's discussing the risk adjusting approach. And he says, starting at line 3, and for the purposes of advancing this concept of risk-adjusted present value, it is sufficient to think about this from the perspective of the payer, the party acquiring the asset, and that, I think, in this case, is the Crown. So it might well be sufficient for Professor Smart to only consider the issue from the perspective of the Crown. But I would submit that that's not sufficient for this court when it's looking to the common intention of both of the parties. And we see a similar concept reflected in the testimony of Professor Bodway when he was questioned about the risk adjusting approach as well. And we've contained that starting at page 97 of the oral compendium, but I'd take you to page 98 specifically. And this was at the point in Professor Bodway's cross-examination, Your Honor might remember, he was being questioned about the fairness of the risk adjusting approach and on the terms provided by himself and Professor Smart that the approach would not be fair to both of the parties. And his answer starting at line 6 is, from the point of view of the Crown, if you accept our estimate of the amount that the Crown would be willing to pay, from the point of view of the Crown, they are fair because the Crown doesn't pay any more than its willingness to pay if it pays the Vidal-Anderson annuities based on it. That's based on the risk-adjusted present value. So again, to Professor Bodway, the risk-adjusted approach is fair to one of the parties. It's fair to the Crown, but there's no suggestion that it's fair to the Anishinaabe. And in the report, in discussing the justification for the risk-adjusted approach, Professor Bodway and Professor Smart argued that it's beneficial to the Anishinaabe, and the justification that they provided is because it smooths out the annuities over time, which therefore would protect the Anishinaabe from the risk of large income shocks.
So it's because of this argument that I asked Mr. Schachter if there was some thought the annuities had to be set as a fixed annual payment. And he said, no, the only characteristic of an annuity is that there's an annual payment. But I suppose I should have asked Professor Smart or Professor Bodway, is that the basis, is that the foundation of this opinion, that it smooths them out? That you have to fix something? That it's better to fix something than to have fluctuations?
So perhaps I'll attack Your Honor's question from a few different points. And that is, I don't think any party is arguing here that the annuities need to be some fixed amount in terms of a fixed number year to year. And even the risk-adjusted approach accepts that the annuities, the precise amount of the annuity from year to year would vary, would fluctuate.
So the only mischief he's trying to correct when he says it smooths it out is the mischief of annuities going up and down as opposed to going down.
Well,
because he's offering or they are offering an approach that has a steady decline.
right. Well, so the first point I would make is that actually the risk adjusting approach doesn't relate to this justification at all. And Professor Smart was questioned about this, and he admitted that the justification for smoothing out, that relates to their so-called Vidal-Anderson annuities machine or model, what I believe Ontario is now calling the Bodway-Smart approach. And that's the proceeds go into a capital sum and the annuities are taken from the interest generated from that amount. That's where the so-called benefit of smoothing out comes from, and I'll return to that in a second. But the risk-adjusted approach actually doesn't relate to that justification at all. The risk adjusting is not where the benefit of smoothing out the annuities comes from. And so in fact, there was no justification for the risk adjusting approach from the Anishinaabe point of view. And as Professor Smart admitted, these are separate aspects of the model that he was proposing. The so-called Vidal-Anderson approach and the risk-adjusted approach were two elements of the model. They're not dependent upon each other. And he demonstrated that by showing how you could use the annuity machine model, the Bodway-Smart capital sum model, using different sums that go into the capital sum, one of which was the risk-adjusted approach. So they actually are separate aspects of the approach that Professor Smart was advocating for. And so when it comes to the so-called Vidal-Anderson approach, the Bodway-Smart approach, that's where the benefit, the alleged benefit of the smoothing out comes from. And the benefit that Professor Bodway and Smart described is the fact that, well, you don't have larger fluctuations in the annuities from year to year. They always accepted, well, the precise amount of the annuity will fluctuate from year to year, but under our model, it will fluctuate less. And they allege that that was a benefit to the Anishinaabe. And we don't accept that that is a benefit that the Anishinaabe.
So the fluctuation issue, size of fluctuation, is addressed by their general approach of the capital account.
That's correct, not by the risk adjusting approach.
Okay.
And so that's why we say that there's actually no justification for the risk adjusted approach, that aspect of their approach, when you look at it from the perspective of the Anishinaabe. They're not getting anything from the fact that.
Well, they're not getting that benefit.
They're not getting, well, we would say they don't get any benefit from the risk adjusting approach.
No, but you're addressing their justification, and you say they don't get that benefit.
Right.
Even if it is a benefit, they don't get it.
Precise. Well, because it's not connected to risk adjusting. It's connected to another aspect of their approach.
Let me just catch up for a moment, please. I'm just going to ask you if I have this right. So the benefit, in quotes, of lower fluctuations or reduced fluctuations does not flow from risk adjustment.
That's correct.
Go ahead.
And so far from a benefit to the Anishinaabe, the risk adjusted approach is completely at odds with what this court heard about the Anishinaabe worldview. And Mr. Schachter addressed this somewhat as well in his submissions, but I wish to remind the court that a central component of the risk adjusted approach is that the Anishinaabe share of revenues from the land decreases each year. And that's because, as Professor Smart proposed, the revenues in the future become riskier and riskier. So a smaller and smaller percentage is shared with the Anishinaabe. It's reduced to less than 1% as of 2023. And if we follow the model into the future, the Anishinaabe share will continue to decline, to become smaller and smaller, approaching 0%. The way the math works, it can never actually become 0%, but it can become 0.1%, 0.01%, smaller and smaller numbers into the future. And so for the rest of time going forward, the Anishinaabe will receive somewhere between 1% and 0% of the NCRRs. And it's a smaller and smaller number the further we get into the future. And so I would ask the rhetorical question, based on what we've heard about Anishinaabe culture, views, and expectations, would the Anishinaabe in 1850 have agreed to such a proposal? And I would submit that the answer to that question is quite obvious. Of course they wouldn't. Would not, wouldn't. And a consistent theme that the court heard throughout the testimony of the chiefs and elders was the importance to the Anishinaabe of looking out for future generations. They testified to a deeply held belief that they must ensure that the future generation is better off than themselves. And this theme was evident in the testimony of each and every Anishinaabe witness on stage 3, from Elder Donio to Chief King. Now, some of them spoke about the principle in terms of cultural principles, such as Elder Donio. Some spoke of it in terms of the responsibilities of Anishinaabe leadership. That would be Chief Mishano, Chief Tangi, then Councillor Solomon. And some spoke of it in terms of their own personal relationship with their parents and children. And that came through in the testimony of Elder Goodchild. And of all that evidence, I wish to highlight only one piece, though, as I mentioned, each and every one of the Anishinaabe witnesses spoke about it. But for today, I'll just take you to an aspect of the testimony of Elder Donio that we've included at page 100 of our compendium.
I just ask you to go back for a minute. You said from Elder Donio to, and did you say Chief Ken?
Chief King.
King.
Chief King, Chief Wilford King of Galway.
Thank you.
And that was just the chronology of the Anishinaabe witnesses. Elder Donio was the first to testify. Chief King was the last.
Thank you.
And Elder Donio testified about how this principle took form in the Anishinaabe belief regarding obligations to the next 7 generations. And we've included that aspect of his testimony at page 100 of our oral compendium. And his answer, the testimony begins at line 24. Well, it relates to other generations in terms of us being taught that our obligations extends beyond us. Our obligations extend beyond our immediate family, our extended family. Our obligation extends to other generations. We talk a lot about 7 generations. So let's not think about today, let's not think about tomorrow, but let's think about those who are going to be coming after us. And a little further down at line 12, he said, let's be mindful of that what are we going to do today to hopefully attain a better lifetime for them, for the yet unborn, and that's how it was always referred to. And so the point of this testimony was that to the Anishinaabe people, they see their relations extend to other generations. Their obligations extend beyond those presently alive to future generations, as far as 7 generations into the future. And given these obligations, it is inconceivable that the Anishinaabe in 1850 would have agreed to a promise that gave them 100% of the NCRRs from 1851, but saddled their future generations with receiving less than 1% forever into the future. And Professor Bodway and Professor Smart attempted to get around this issue by claiming that risk adjusting actually benefits the Anishinaabe because, in their view, it means that they're bearing a much smaller percentage of the large losses in net crown resource revenues in recent years. So they actually say, well, the Anishinaabe should be happy about our risk adjusting approach because it means they only need to share 1% of these massive losses in net crown resource revenues in 2019, 2018, 2017. And I have 3 responses to that argument. The first is that we obviously don't accept that net crown resource revenues have been massive negatives for so many recent years. But secondly, even accepting their negative NCRR numbers, which we do not, there's no evidence that the NCRRs will remain largely negative into the future, when under their model, the beneficiaries would continue to receive less than 1%, even if NCRRs turn positive in 2020, 2021, et cetera. And finally, there's no reason to believe that the Anishinaabe in 1850 would have suspected that NCRRs would be positive in the immediate future and would then turn negative about 150 years into the future. To say, well, let's accept a bargain based on risk-adjusted NCRRs because I have a suspicion that starting in 1960, the Crown is going to incur a large amount of expenses in forestry and the NCRRs are going to be negative. And in fact, if anything, likely the opposite would have been true, that the parties would have believed that initially the expenses might have been high to get the industries up and running in the territory, but then would be positive after a few years. And I believe there was evidence from stage one that Your Honor already discussed about how the expectation of the Anishinaabe to augmented annuities after a number of years. And so
One way to look at it, that it had the Anishinaabe been receiving some share of the resource wealth in the first 100 years, like the government of Ontario, who says there are no profits to be made from the resources in the territory, neither would they have been needed to rely on profits from the resources, because they would have been seeing those numbers, engaged in a process, and receiving funds that would have allowed them to do other things. Am I going too far there?
I'm perhaps I'm a little bit confused by who the they is in your question. That the Crown would have been receiving other funds?
No, that had the Anishinaabe been in funds for 100 years post-treaty, even if the resource was no longer producing a profit for either Ontario or the Anishinaabe, they wouldn't have been dependent on that resource, just like Ontario is not dependent on it.
Well, I think there are multiple aspects to the question, multiple answers, and
I come to that from this point you make. There's no reason to believe the Anishinaabe would have suspected something 100 years later. There's so many things they wouldn't have suspected.
Right. And I think your question is accurate, that and that's part of what I'll get to about the lost opportunity and the lost opportunity to have used these funds. And I think Your Honor is absolutely right. Had the Anishinaabe been receiving these funds in the first 100 years of the treaty bargain, they would have been able to have put those annuity funds to use for the benefit of their communities. And I'll speak about that a little bit later, but they would have been able to use those funds to bring up the well-being of the community, the standards of living of their communities, and then perhaps be in a much better position to face downturns in natural resource levels in the territory in the future, which again, we don't accept that the NCRRs have become these massive negative numbers starting in 1960. I'll add that caveat, which is necessary. And the other aspect of Your Honor's question.
Sorry, just to be sure, when you say you don't accept that the NCRRs have been massively negative for the last 50 years, are you talking about NCRRs as defined by Ontario?
By Professor Smart and Professor Bodway, that's correct.
Okay.
It was on their evidence that the NCRRs, as they calculated them, began turning negative in about the 1960s and have been these very large negative amounts ever since. And we don't accept that evidence. And we submit that the evidence of Mr. Hutchings ought to be preferred on that point. And the other aspect of Your Honor's question that I wanted to get to is the other aspect goes to this loss of the opportunity to engage in a process. And had the NCRRs from the resources begin to take this nosedive in the 1960s, which again, we don't accept that they did, but had the Crown been honoring its commitment to engage in the process with the Anishinaabe, they would have been able to come together and discuss that fact and discuss how to address it as treaty partners. If this is going to impact the treaty bargain that we made in 1850, that the circumstances are changing, how do we address that to ensure that the substance of that treaty bargain is upheld and that the Crown continues to act honorably and diligently implement that treaty term? And of course, because the Anishinaabe lost that opportunity to engage in that process, they could never have those discussions, even if the nature of resource extraction in the territory, of the economics of resource extraction began to change, which again, I'll add the caveat one more time, we don't accept.
So, am I wrong in saying that pie chart that Mr. Schachter pointed us to, that shows that very thin gray sliver of income from resources is not something you accept, or?
So we accept that in modern times, the revenue to the Crown, the percentage of the revenue that comes into the Crown of all revenues, the percentage that comes from resource revenues is smaller. And I believe that was the purpose for which Mr. Schachter was referring to that evidence. But that's a different question than have the net Crown resource revenues become negative due to exploding expenses. As I understand the evidence that Mr. Schachter was referring to, that relates to more to the growth of other sources of revenue. For example, the explosion of the percentage of government revenues that come from income taxes. Of course, it was a much smaller percentage in the 19th century. It was zero in the 19th century when income taxes didn't exist. So now as the modern governments have developed other sources of revenue, the percentage of their revenues that come from natural resource extraction makes up a smaller percentage. I believe that was the nature of the evidence and the purpose for which Mr. Schachter was referring to.
That's helpful, thank you.
And the final point that I wish to make about the risk adjusting approach and why this court should reject it is because it should reject the evidence of Professor Smart, who was a partisan advocate. And we submit that Professor Smart was not a credible witness who demonstrated adherence to his obligations as an independent and objective expert. And Mr. Schachter already spoke in the start of his submissions about the ways in which Professor Smart showed himself to be unhelpful, argumentative, and defensive in seeking to advocate for Ontario's position. And of course, Your Honor had a front row seat to view Professor Smart's demeanor on the stand. And so I only wish to highlight a few additional aspects of his testimony that demonstrated his tendency to rely on over-exaggerations and bombastic claims, and to unnecessarily denigrate Mr. Hutchings, who for some reason he seemed to view as an opponent. And the first piece of evidence that I wish to take this court to is the surreply report, which is Exhibit 63, and we've contained an excerpt of it at page 104 and 105 of our compendium. And specifically at page 105, we've reproduced paragraph 38 of the surreply report. This was the surreply report of Professor Bodway and Professor Smart responding to Mr. Hutchings. And the professors wrote, Mr. Hutchings states that we included fish and wildlife management spending in the 1997 to 2011 period.
Sorry, I'm just looking for it.
I'm at page 105
Thank you.
of the oral compendium. And it's paragraph 38 of the report is what I'm reading from. It should be highlighted on your honor's version as well.
I've got it. Thank you.
And they write, Mr. Hutchings states that we included fish and wildlife management spending in the 1997 to 2011 period. His statement is categorically incorrect. We did not include this item in our accounts. Mr. Hutchings simply failed to understand the computer instruction files that we included in our work papers. I would submit not only was that statement unnecessary, but it was of course incorrect. As Professor Smart later admitted in his testimony in court, Mr. Hutchings was actually correct in this point about his criticisms, and it was Professor Smart who was in error. The next piece of evidence I wish to go to is slide 71 of Professor Smart's demonstratives, and that's included as exhibit 70 on stage 3, and we've reproduced it at page 107 of the compendium. And it was on this slide where Professor Smart was responding to Mr. Hutchings' criticism of his use of a logarithmic scale. And Mr. Schachter discussed this issue, and I don't wish to get into the merits of the issue on the use of the logarithmic scale, but what I wish to point out is the language that Professor Smart decided to use to respond to Mr. Hutchings' criticisms. And that's on the third bullet of his slide. He writes, and he repeated the point in his oral testimony as well. He writes, Mr. Hutchings might not know that economists commonly use a logarithmic scale to show growth processes. And Professor Smart could have easily made the point that he believed that there was no issue with using a logarithmic scale. But for some reason, he found it necessary to take what I would describe as a pot shot at Mr. Hutchings. And the final aspect of Mr. Smart's evidence that I wish to highlight on this point is that in his testimony, he claimed that Mr. Hutchings effectively excluded, that was his words, effectively excluded all expenses after 1945. And of course, that's not an accurate description of what Mr. Hutchings did. We admit that he did not rely on the public account data because he found it unreliable, and Mr. Schachter went into great detail in his submissions about why Mr. Hutchings reached that opinion. And so as a result, he used a ratio of expenses, and he did include expenses in the post-1945 period. He subtracted around 31% of all revenues as expenses. But in his testimony, Professor Smart claimed that he effectively didn't count any expenses after 1945. And even when he was cross-examined on this point, Professor Smart refused to even acknowledge that his language in this regard was hyperbolic in any way. And hyperbolic in any way. And I'm not going to take the court through that aspect of the testimony now, but I would note that we have included it in our oral compendium, starting at page 109 and 110 of the compendium. So you can, if your honor wishes, can re-review the aspect of Professor Smart's cross-examination on this point. And why do I raise these aspects of Professor Smart's evidence? Because my point is that such statements are inconsistent with the duty of an expert to be fair, objective, and nonpartisan as set out under Rule 4.1 of the Ontario Rules of Civil Procedure. And for that reason, we submit that Professor Smart's testimony, and specifically his testimony regarding the risk adjusting approach, should be given less weight. And I think perhaps that's a good place for us to take the afternoon break.
Thank you. We'll take the break, 15 minutes, and I will stay here.
This court is stood down for 15 minutes. This court is resumed. Please be seated.
Good afternoon, Your Honor. And just before I get into my next topic, I wanted to return very briefly to one of the areas I was speaking about before, and that's when I was discussing the risk adjusting approach and the large negative amounts from Professor Smart and Bodway for post-1960. And of course, I just wanted to remind the court of Mr. Hutchings' evidence that, of course, he found actually significant positive amounts from that period forward in his NCRR calculation. So lest I be misunderstood to be admitting that there were negatives, but there just weren't as large negatives as Professor Smart or Professor Bodway found, that's not our position. Our position is in fact that the evidence of Mr. Hutchings on this account should be preferred, and that in fact there were these positive amounts for direct NCRRs even in the last 50 or 70 years.
Thank you.
And so the area that I want to turn to now is the principles of equitable compensation. And we say that this court can and should have recourse to the principles of equitable compensation in order to craft a fair and just remedy in this case. And the Group of Seven agrees with Canada's submissions to the extent that remedies for breach of treaty and breach of honor of the Crown must be sui generis, and they must be responsive to the particular circumstances of the case, including the nature of the treaty promise and the nature of the breach. And this may involve drawing on principles from both common law damages as well as from equitable compensation where necessary. And nevertheless, I do want to speak about this topic because both Ontario and Canada have attempted to exclude certain principles of equitable compensation, arguing that they are exclusive to fiduciary duties, which of course the Court of Appeal rejected apply in this case. And nevertheless, despite the absence of fiduciary duties, we maintain the position that principles of equitable compensation are necessary and appropriate in this case and should properly be applied by the court. And I want to start this discussion with the comments of the Court of Appeal in the Stage 1 and Stage 2 decision. And that's their discussion in determining that fiduciary duties were not necessary in this case. And it was in framing this discussion that Justices Lowers and Pardue specifically noted that, quote, the trial judge found the imposition of a fiduciary duty necessary in part to ensure the availability of equitable remedies. And that's at paragraph 255 of the Court of Appeal decision. And I raise that because that was the context in which they asked the question of whether the concept of fiduciary duty has any work to do that is not already done by honor of the Crown. It was in relation to equitable remedies, which is why they were asking that question. And so it was in that context that the justices said, no, the honor of the Crown is sufficient. And that's, I would take the court briefly to paragraph 256 of the Court of Appeals decision, which we've reproduced excerpts of. And I'm at page 114 of our oral compendium.
Thank you.
And that's where Justices Lowers and Pardue write, in the particular circumstances, does the concept of fiduciary duty have any work to do that is not already being done by honor of the Crown? And they refer to the Peter Ballantine Cree Nation case from the Saskatchewan Court of Appeal and how they endorsed Dixon's view that the generalized fiduciary obligation in form, a principle that calls for honorable conduct, has been largely replaced by the honor of the crown principle, which effectively mandates the same thing. And then the Court of Appeal says, we agree. And at paragraph 257, the court discusses the different model of the honor of the crown and the duty of diligent implementation. And at the end of that paragraph, they write, where the duty is breached, it's being the duty of diligent implementation, a court may order remedies aimed at ensuring that the crown fulfills its treaty promises. And I think that's the core point when it comes to this court's remedial jurisdiction, is that in the face of the breaches by the crown, the breaches of the treaty, the breaches of the duty of diligent implementation, the breaches of the honor of the crown, this court may order, and indeed we would submit should order, remedies that are aimed at ensuring the crown fulfills its treaty promises. And so my point here is that the Court of Appeal found that fiduciary duty was unnecessary to bring in concepts of equitable remedies because that can already be done through the honor of the crown and the duty of diligent implementation. And Ontario invites you to ignore this aspect of the Court of Appeal's decision in arguing that equitable remedies have no role to play in this case because there is no finding of a fiduciary duty.
You're saying the full range, that the Court of Appeal didn't limit what equitable remedies were available, and you say the full range of equitable remedies should be available as per the Court of Appeal's words.
That's correct. And the underlying remedial question, excuse me, in the case should be what is required to enforce the honor of the crown? What is required to effect reconciliation? If that requires drawing from principles of equitable compensation, principles of equitable remedies, that would be appropriate. If it requires drawing from principles of common law damages, that should be appropriate. And no remedial option should be off the table simply because there's no fiduciary duty at play here.
This may be a problem with language only, but I wonder if you're saying the court affects reconciliation by making an order, a certain order, whatever that order is, or do you say the court can order the crown to take certain steps which would affect reconciliation?
I think kind of the formulation is a bit of a question of form over substance. I think the result is the same, whether you're saying that it's the court's order itself that is endeavoring towards reconciliation, or that the court is making orders binding upon the crown, which will require the crown to effect reconciliation. I think the result is ultimately the same at the end of the day.
There are those who say the court has no role in substantively in achieving reconciliation, maybe in process. I can't tell you all what those who say that say, but so I just put it to you.
Right. And my submission on that point would be whether it's the court playing that role itself or whether that role is being played through orders directed towards the crown. I think all Canadians have a role to play in effecting reconciliation. And in a case involving long-standing breaches of the honor of the crown, the principles of reconciliation, when the court considers remedies, are certainly relevant considerations.
Thank you.
And on that point, I note that Mr. Schachter did discuss aspects of equitable remedies and remedies for breach of honor of the crown. So I don't want to be too repetitive here. I will simply highlight the fact that, of course, equitable remedies are purposive And the role is for the court to find the remedy that best protects the important relationship at the heart of the obligation. And certainly the Crown Indigenous relationship that lies at the heart of the treaty relationship in this case is no less important than a fiduciary relationship. Indeed, the Crown Indigenous relationship is a fiduciary relationship, even if fiduciary duties themselves are not present. And it's a relationship that is no less worthy of this court's protection. And in terms of the honor of the Crown, the Court of Appeal, referring to the Supreme Court's decision in Haida Nation, explained the overarching question in cases of where the honor of the Crown comes into play. And I would take you to paragraph 233 of the Court of Appeal decision, which again is reproduced at page 112 of our oral compendium. And the Court of Appeal, again, this is Justices Lauer and Pardue writing. We repeat Chief Justice McLaughlin's strong statement, and they're quoting from Haida Nation at this point. The controlling question in all situations is what is required to maintain the honor of the Crown and to effect reconciliation between the Crown and the Aboriginal peoples with respect to the interests at stake. And based on that, we say that remedies for breaches of the honor of the Crown, similar to equitable remedies, should not be unduly constrained by formalism. The question for the court should be formulating a substantive remedy that will maintain the honor of the Crown. And in some cases, as in this case, that may require importing principles from equity. And that point actually brings me quite nicely into what I wanted to speak about next, which is the Ontario Court of Appeal's recent decision in the case of Chippewas of Nawash Unceded First Nation and Canada Attorney General. I have a hard copy of the decision, which I'm happy to hand up to the court if Your Honor would find that useful.
Thank you. That would be useful.
And I've offered copies to my friends, but I believe they all have their own copies or their own electronic versions that they're working off of.
And I appreciate, Mr. Bass, your conservation of resources. But my eyes can't read this font. I'll manage, but.
My apologies. So as Your Honor asked earlier this week for the parties to discuss the relevance of this case, I do wish to make a few comments about the impact of the Court of Appeal's decision on the matters before us. At bottom, the case doesn't fundamentally change the landscape of our task here, but there are statements from the Court of Appeal that are relevant, and we believe this court should take into account in its decision in this case. And particularly a number of statements from the Court of Appeal that we submit support the plaintiff's position, and particularly in the topic of the availability of equitable remedies, which I was just discussing. So the first aspect of the decision that I want to discuss is about how the Crown's competing interests can be considered in a case of breach of treaty and where the honor of the Crown is at issue. And for this point, I would direct you to paragraph 153 of the Court of Appeal's decision. And I would point out this was a unanimous decision of the court, and it might be of note that Justice Lauers and Justice Pardue were both on the panel that decided this decision, and of course they are familiar to us in this case. And so at paragraph 153, the court writes, Finally, Ontario argues that the trial judge erred by suggesting that the Crown could not take competing responsibilities and obligations into account when implementing a treaty promise. First, we accept that competing Crown obligations can be considered in evaluating the duty of diligent fulfillment, but how and to what extent depends on the facts of each case and the nature of the treaty obligation. Consider the impugned passage in the trial judge's reasons found at paragraph 922, quoting from the trial judge, to the extent that there were pressures from the white population for land, the Crown had already committed to protecting the peninsula from those demands in the encroachment clause, a reference to the specific nature of the promise. In our view, the trial judge's analysis simply recognizes the obvious, which is that the Crown's honor cannot be compromised by interests that are axiomatically opposed to those that the Crown has promised to protect. Stated otherwise, white settlers' need and desire for land on the peninsula is not a competing interest, but one that is diametrically opposed to the Crown's promise. And so what the Court of Appeal is saying here is that the relevance of competing Crown obligations to the duty of diligent implementation depends on the facts of the case and the nature of the treaty promise. But that being said, the Crown's competing obligations to other parties are not a license to ignore its solemn treaty promises. And in this case, the plaintiffs have always accepted that the Crown may have other policy objectives and competing obligations that may impact its decisions regarding, for example, the amount of extraction to authorize in the territory and the amount of resource rents to capture. But the existence of those competing obligations don't do away with its solemn promise to share in the wealth of the territory with the Anishinaabe. And how does this take concrete form in this case? Well, for one, the plaintiffs have accepted the Crown's decisions on the level of extraction to allow in the territories.
Accepted as in not challenged.
Precisely, we don't challenge it. So no party and no party on this side of the courtroom. Well, I note that members of Canada's team are sitting on this side of the courtroom as well. But on the plaintiff's side,
Sharing the territory.
precisely, we have not argued that compensation should be based on the quote unquote optimal amount of extraction. So for example, trees that were not cut down, minerals that were not taken out of the ground. We're not arguing that compensation should be based on some hypothetical world in which the Crown optimally extracted the resources from the territory. We accept the Crown's policy decisions, which may be based on other objectives and competing obligations, to determine the level of extraction that it's going to authorize and allow within the treaty territory. And further, we would note that the Crown's competing obligations and its obligations under the augmentation clause can easily fit together. And Mr. Schachter talked about this point at length, which is that the Crown can choose to capture less of the rents in order to foster other interests, other policy objectives. But its treaty partners should not be required to bear the detriment of those decisions.
And Mr. Schachter referred to that as the Carney model.
Precisely. That's what I'm referring to when I reference Mr. Schachter's submissions there.
Thank you.
And I would note as well that it is precisely the engagement process that the treaty mandated and Your Honor recognized in the stage 1 decision that would have enabled the Crown and the Anishinaabe to come together and reach agreement on how the Crown's other interests and its treaty obligations could fit together comfortably. that likely would have been one of the main, if not the main topics of discussion in the engagement process. But in breaching its duty, the Crown ignored its treaty obligations and ensured that this process could not play out.
Well, you say ignored their treaty obligation. The treaty obligation that you say they ignored is the engagement
The
process.
engagement process.
So by ignoring the obligation to engage in a process, you say they didn't let the process play out, but in fact, what didn't happen was the fit of those two things.
Right, and perhaps I could have been more clear here in referring to, of course, there are two treaty obligations that I'm discussing here. One is the obligation to engage in the process, and the other obligation being the obligation to augment the annuity clause when the circumstances warranted. And through the first obligation, through the engagement process, the parties could have come together and had that discussion of how does the other obligation, the obligation to augment the annuity, how can it fit together with the Crown's competing obligations?
So they didn't, I'm just trying to give this back to you. By ignoring their obligation to process, neither the Crown nor the Anishinaabe had a chance to design a process that managed the policy, the Crown policy goals with the Anishinaabe aims and expectations under the treaty.
That's right. And I would say manage the implementation of the annuity augmentation in a way that reconciled, I'll use the word reconciled, the obligations of the Crown to augment the annuity with other obligations that the Crown might have to third parties, to non-Indigenous Canadians, other policy objectives that the Crown might have. And that's when we're looking at the facts of the case, the nature of the treaty obligation, to consider how the competing obligations of the Crown come into play here. That's what's relevant. And that's what the Court of Appeal at paragraph 153 of the Chippewas of Nawash case is saying, how the competing obligations of the Crown come into play when we're considering the duty of diligent implementation. Well, that depends on the nature of the case. It depends on the circumstances, depends on the particular treaty obligation that we have here.
Would it be fair to use as a short form for the Crown's competing interests, economic development in the region?
I think that comes into play. I'm just hesitant to set up economic development in the region as somehow opposed to the interests of the Anishinaabe, as if they're diametrically opposed and one must give for the other to be benefited. Certainly there are ways that economic development may well benefit the Anishinaabe population of the territory as well.
I shouldn't have put it so much as a competing interest as a policy goal.
I think that's certainly one of the policy goals that the Crown may well have in mind in considering questions that would impact its treaty obligations, would impact the level of net Crown resource revenues, impact the level of resource rents that is captured, those sorts of decisions.
Thank you.
And the other aspect of the Court of Appeal's decision that I want to discuss is how the Court of Appeal reaffirmed the applicability of equitable remedies for breaches of the honor of the Crown and the duty of diligent implementation. And in our view, this is actually the most important aspect of the case, at least for our purposes. And I'll just remind the court of the important context of the Court of Appeal's decision. And that is that the trial court found and the Court of Appeal upheld that the Crown in that case did not owe a fiduciary duty to the plaintiffs, they refer to as the SON, But nevertheless, the trial judge found, and again, the Court of Appeal upheld that finding as well, that the Crown did breach its duties to act honorably and diligently implement the treaty, specifically in not doing enough to prevent encroachments on the Bruce Peninsula by white settlers, and in comments that were made by Mr. Anderson in the negotiations leading up to Treaty 72. And if Your Honor is wondering, yes, that is in fact the same Mr. Anderson of Vidal and Anderson fame.
Busy guy.
And in this regard, I would take the court to paragraph 209 of the Court of Appeals decision. And there the court writes, here, the imposition of a fiduciary duty would add nothing to the Crown's obligations to diligently and purposefully perform the treaty promise. As observed in Beckman and Little Salmon, the Supreme Court has over time substituted the principle of the honor of the Crown for a concept, the fiduciary duty, that in addition to being limited to certain types of relations that did not always concern the constitutional rights of Aboriginal peoples, had paternalistic overtones. And then at paragraph 210, the court goes on.
They footnote themselves?
I was going to make the point actually that the court at paragraph 209 and 210 does not cite the Restool decision, its earlier decision in this case, but of course it could have. And at paragraph 210, they write, where a Crown obligation is grounded in the honor of the Crown, it may not be necessary to invoke fiduciary duties. The Crown is still obliged to comply with its constitutional obligations in a manner consistent with the honor of the Crown. And I would submit that the court here isn't really saying much more than it said in its decision in this case in stage 1 and stage 2. And that's simply that it may not be necessary to invoke fiduciary duties where the honor of the Crown already obliges the Crown to diligently comply with its constitutional treaty promises. And in assessing the remedies available in the case, and I'm returning now to the Chippewas of Nawash, the Court of Appeal finds that the remedy that was sought by the SON of a constructive trust is inappropriate in the circumstances. And specifically, the court finds that that remedy would be disproportionate to the wrong that was committed by the Crown. The SON, I believe, asked for a constructive trust over various roads on the Bruce Peninsula. The court says that would not be an appropriate remedy here, given what we found regarding the magnitude of the breach. But the court does then make comments on what types of remedies would be appropriate, would be available. And at paragraph 280, the court writes, the court goes on to accept that Anderson's ill-considered remark in 1854, and I'll pause there, just the ill-considered remark was one of the aspects that they found brought dishonor on the Crown. So they say Anderson's ill-considered remark in 1854, which the trial judge found had no effect on SON, might merit symbolic, equitable financial compensation from the Crown. So the Court of Appeal is saying that equitable financial compensation might well be available for conduct that breached the honor of the Crown, but was not a breach of fiduciary duty. And then further down at paragraph 292 of the decision.
But you don't need that finding with respect to that remark. Given what the court has already said about fiduciary duty has nothing to do in this context.
Right. So the point that I wish to make now is so once we accept that fiduciary duty has no role to play in this context, there is no finding of a fiduciary duty, no finding of breach of fiduciary duty. We're on all fours in that respect with Chippewas of Nawash. No fiduciary duty in that case, no fiduciary duty in this case. And so once the court says, okay, fiduciary duty has no role to play in these cases, In Chippewas of Nawash, the court goes on to consider, well, what remedies are appropriate, even in the absence of breach of fiduciary duty, to account for breach of duty of diligent implementation, conduct that brings dishonor of the crown. Paragraph 280, they consider one of the aspects of dishonorable conduct. They say symbolic equitable financial compensation may well be appropriate in that case. And then at paragraph 292, the court writes, we are persuaded that equitable compensation payable by the crown would be an effective remedy in the circumstances, and that's referring to the crown's breaches of Treaty 45 and a half. So just to provide slightly more context, one of the claims in the case was that the crown breached its treaty obligations under Treaty 45 and a half. The crown had promised in the treaty to protect the Bruce Peninsula from encroachments by white settlers.
Squatters, yes.
From the squatters. The trial judge found, Court of Appeal upheld. The crown did not take sufficient action, did not diligently implement its treaty obligations in that context. There was a breach of the treaty, breach of the duty of diligent implementation, no breach of fiduciary duty, but the court says equitable compensation payable by the crown would be an effective remedy. So the Court of Appeal here is unequivocal that equitable compensation is available for breach of treaty and breach of the honor of the crown, even where no fiduciary duty exists. And to the extent that there was any ambiguity on that point from the Court of Appeal's decision in this case, that any ambiguity there is now gone. And we would submit that that completely undermines Ontario's arguments that only common law damages can be available in this case. Only common law damages can be available in this case. Even without a finding of fiduciary duty, even without a finding of breach of fiduciary duty, this court can and should consider principles of equitable compensation. And those were all of the comments that I wish to make about the Chippewas of Nawash.
Thank you.
And noting that we do have some time left in the day, I will continue on to my next topic, which is calculating the present value. And the group of 7 submits that this court should employ what has been referred to as the 60-40 approach from Professor Stiglitz and Mr. Hutchings in order to assess the present value of the lost opportunity to the beneficiaries. And I will speak of 2 reasons why we say the 60-40 approach is appropriate. The first is that out of all of the models before the court, the approach comes the closest to actually approximating the beneficiaries' lost opportunities to use the annuities when they were due towards improving the well-being of their communities. And secondly, that the other models that have been presented to this court, whether it's use of the long-term bond rate or what I will refer to as the Booth-Kersner approach, the approach that we heard from Professors Booth and Kersner, they're seriously flawed and should not be employed by this court. And so on the 60-40 approach, we submit that there's ample evidence before this court of what the Anishinaabe beneficiaries would have done with augmented annuities if they received them on time, consistently with the treaty promise. And much of this is credible evidence coming from leaders of these communities and those who are actually tasked with making decisions for the well-being of their communities. Before I get into that evidence, I would also note that this issue, this evidence, should also be considered in the context of the important goal of pursuing Minobamadzwin, which Mr. Gover has already spoken about earlier today, and you've already heard a great deal about both from Mr. Gover and in the evidence, and specifically the role of the communities in assisting their members achieving this goal. And the next piece of the puzzle, so to speak, I would submit is the evidence of Anishinaabe conceptions of saving. And these beliefs as well would have informed what the beneficiaries would have done with additional funds. And that's even prior to economies that were based predominantly on monetary currency like we have today. The Anishinaabe understood the importance of saving for the future to benefit future generations. And Elder Donio put this point well in his testimony, and I would take you to what he had to say on the topic. And that's at page 124 of the oral compendium. And he said, and starting at line 2, so you know, that was the way things were back then. But we need stuff. We needed things. We need stuff for today. We need stuff for the future. You know, savings. We saved all the time. When we hunted, when we fished, we would have a catch that we know we weren't going to devour it all, so we would dry it. We would cut it, we would dry it, and we would save it for the winter months. If we had one moose or more, we would share and we would dry so that we saved. So while we didn't have a bank to run to, say, here, I got another $10, I'm going to go and deposit this in the bank, we saved other things because we knew the value of saving and what we could do tomorrow because we don't have to do it right now. And Chief Tangi, Councillor Solomon, Chief King, they expressed similar ideas in their testimony as well. And more directly, the unchallenged evidence of the chiefs was that their communities would use the additional financial resources to advance community well-being. These included aspects like community-owned businesses or assisting their members to start businesses, spending on infrastructure, on housing, social services like education and healthcare, or clean water. And I would highlight the testimony of two of the chiefs in this regard. The first being Chief Mashano, and I'm not going to go through the transcript itself, but I'm referring specifically here to pages 2328 to 2330 and 2335 to 2339. That's from the testimony of Chief Mashano, and we've excerpted it at tab 30 or page 126 of the oral compendium, so it's there for your honor if you wish to refer to it. And for today, I will simply summarize the points that Chief Machado made in his testimony in these pages, which is that he spoke about how infrastructure is always the #1 priority. He spoke about how his community, Big Tagong Nishnabeg, would have used additional financial resources to improve the clinic that they have, to hire doctors, nurses, dentists. This is healthcare spending. How they would improve mental health care, given the mental health crisis in their community. How they would spend funds on housing because they have a housing crisis on the reserve as well. And one aspect of his testimony here, he spoke about how the federal government may provide funding for things like a water treatment plant or for firefighting services. I think you referred to, they might buy us a fire truck, but the band itself would have to find the money for things like training or honorariums for the staff. And so in order to make use of some of the other funding that they already receive, they would need to expend their own funds in order to train people to work at the water treatment plant, to pay honorariums, to train firefighters in the community, and that this would have been a use for augmented annuities. And he spoke about education spending and the need to pay teachers competitive salaries so that they will stay in the community and teach the community's children, and how they need to physically maintain the facilities, physically maintain the school, infrastructure spending, education spending. And similarly, Chief Tangi of Mishipicoten First Nation spoke about the priorities for her community for augmented annuities had they been received. And again, I'm not going to necessarily take you there, but we have excerpted it at page 135 of our oral compendium. And Chief Tangi spoke about the need to increase capacity in the water treatment plant and the need for more housing for their members. And given the persistent wealth disparities that this court heard much about, and Mr. Gover summarized some of it, these priorities are unsurprising. And what was notable as well was the consistency of the unchallenged evidence as to how the Anishinaabe communities would have used the money owed to them under the augmentation clause, as between the different chiefs and elders who testified. And so, if the Anishinaabe would have spent the annuities on these community and social well-being investments, what can we say about the rate of return that we should apply to capture the lost opportunity, the inability to have spent the funds on these purposes? And the best evidence that we have on this point came from Professor Stiglitz. And so I would take you to an aspect of Professor Stiglitz's evidence that we've excerpted at page 138 of the compendium. This is starting at it's page 790 of the transcripts.
Thank you. Is the and maybe it'll be in this evidence, but all of these things that you have just described from the evidence, do you use the term social capital or investment in? I was wondering if.
Yeah, I think I've been using the terminology of investments in community well-being. I think perhaps investments in human capital might be appropriate. Investments in social capital, I think, would be appropriate as well.
Thank you.
And so I would take you to the evidence of Professor Stiglitz. And again, I'm at page 138 of our oral compendium, starting at line 15. It should be highlighted in your version as well. Professor Stiglitz said, actually, what they would have done, given the level of deprivation, would have invested in infrastructure, education, health, and that would have yielded a far higher return. And he was being questioned about the 60-40 approach at this point. So when he says a far higher return, he's referring to far higher than the rate of return on the 60-40 approach. And he goes on, so as I explained in my testimony, the numbers here, I think, are very conservative relative to what the opportunity costs would have been if they could have actually had that money and invested it in providing for the community in jobs, infrastructure, education, and health. Again, I would pause here, jobs, infrastructure, education, and health. That mirrors the evidence that you then heard from Chief Machano, Chief Tangi, about the investments that they would have made, the priorities for their community. Professor Stiglitz goes on, so these numbers, I believe, and these numbers, he's referring to the rates of return for the 60-40 approach. So these numbers, I believe, are too low. He goes on a little bit later at the next highlighted portion down at line 16. And what I'm saying is this is a lower bound on the opportunity cost. If that community had gotten together and had those resources, they would have done something that would have yielded a far higher return than I believe these numbers represent. They would have been able to invest in education and health and infrastructure and jobs, and the returns on that would have been much higher, and they would have been much better than even the numbers we put here would have said.
And these numbers are 60-40 numbers?
The rate of return for the 60-40 approach, precisely. And so the point that Professor Stiglitz makes, the point that I'm making here now, is that the 60-40 approach is likely an undercount. It's actually an undercount, an underestimation of the rate of the return that the Anishinaabe could have and would have obtained from the augmented annuities they were owed. And we're not asking the court today to actually quantify the rate of return for infrastructure spending, education spending, healthcare spending, and determine the percentages that would have gone to all of that. We rely on the fact that the 60-40 approach is therefore a conservative estimation of the value of the lost opportunity. And so we urge this court to employ the 60-40 approach because it does the best job of any of the models before this court of getting closest while still underestimating the value of the lost opportunity. The next aspect that I was going to get into related to the 60-40 approach is the government control over the band trust account rates and why that's actually irrelevant. We can pick up with that tomorrow morning if that's the court's preference.
Thank you. Okay. Thank you. For today, we'll break now until 10 and tomorrow. And I will be staying here after I close court.
All rise.
Thank you.
This court is adjourned until September 15th, 2023 at 10 a.m.